Good afternoon. Welcome to the third of these series with regard to legal issues stemming from the coronavirus COVID-19 pandemic. What I want to talk about this afternoon is civil liberties in a pandemic. There's no doubt that the government has broad authority to take actions to stop the spread of communicable disease. There's also no doubt that governments can use this authority for unnecessary suppression of basic rights. We've seen it around the world in just the last month. We've seen Hungary and Bolivia canceling elections. We've seen countries like Hungary, Jordan, Thailand using this to suppress speech. In Hungary, any speech that's seen as interfering with fighting the pandemic is punishable by 5 years in prison. In Jordan, anyone who spreads false news with regard to the pandemic can be criminally prosecuted and sentenced to prison. Israel has used this as the basis for closing down the courts, for using technology to track the movements of cell phones. Now, let's talk about in this country, we've seen some states use this as a basis for prohibiting all abortions. We shouldn't be sanguine in this country that our commitment to civil liberties will keep us from the infringement of fundamental rights in a crisis. In fact, American history gives us every reason to worry. Throughout American history, whenever there have been crises, the response has been repression, and we come to realize in hindsight that it was unnecessary. In the Civil War, Abraham Lincoln suspended the writ of habeas corpus. During World War I, a federal law was used to punish those who criticized the draft and the war effort. During World War II, 110,000 Japanese Americans were uprooted from their lifelong homes and placed in what President Franklin Roosevelt called concentration camps. We saw after 9/11 the deprivation of fundamental rights of Muslims and of those of Arab descent. There are always pressures in a crisis to take away rights. Public pressure calls for immediate action, and public pressure is rarely in favor of protecting rights, especially when it comes to the rights of minorities and the rights of those who are unpopular. Also, crises create an impulse to centralize power. We saw that in the Depression. We saw that in wars. At the same time, in a crisis, there's a desire to defer to expertise, or even so-called expertise. And so there's reason to be concerned about civil liberties in this country in the time of a pandemic. That's what I want to address in my remarks this afternoon. I'll leave a lot of time for questions. I don't want to duplicate what Dan Farber covered in his terrific talk 2 weeks ago on presidential power with regard to emergencies and pandemics. And next week, Andrea Roth is going to be a talk in this series with regard to the criminal justice system in light of the pandemic. So I'm not going to be covering that either. I do want to, in this talk, to do a PowerPoint presentation. As I've said on other occasions, when I've tried to do PowerPoint at faculty and staff meetings, I don't usually use PowerPoint. I am not competent with PowerPoint, and using it in the context of remote learning is even more intimidating to me. But the alternative PowerPoint would have been you're having to look at me for the hour, and PowerPoint seems much better. Also, I wanted to give you citations to the cases that I'll be talking about, and those will be on the screen. If anyone wants these slides afterwards, just send me an email and I'm glad to share them. Also, I want to focus a lot on the language of particularly recent cases. There's been a lot that's happened in just the past week, and I think it's important to see the language that the court used, and having that up on the screen would be helpful as well. As I said, at the end of my presentation, be glad to take questions and hope very much that the others who are experts in the field, other constitutional law professors, will chime in answering. It's certainly an area where there's a lot more uncertainty, a lot more questions than answers. I'm going to divide my presentation into 2 parts. First, I want to talk about some general principles, and then I want to focus on how these apply to specific areas. And I want to talk about a number of specific areas with regard to civil liberties in the time of a pandemic. I want to talk about the government's power to quarantine. I want to talk about the abortion restrictions. I want to talk about the First Amendment with regard to religion and speech. I want to talk about elections and what occurred last week in the Supreme Court. Also, I want to talk here about whether there might be claims under the Takings Clause, and finally, the right to travel. Before I begin, one thing you may not have heard yet, this morning the Supreme Court released an order that it will be doing oral arguments by telephones for 6 days, 3 in each of the first 2 weeks of May. And the order says it's going to make available to the media to listen to live streaming. This will be the first time there's ever been live streaming of a Supreme Court argument. The Public Information Office of the court said that will also be available to the public to listen to. And so it's some of the cases that were to be heard in March and April will be heard the first 2 weeks of May. That includes the 3 cases that involve subpoenas of President Trump. So with that as my introduction, let me see if I can go back to doing the slideshow and begin my talk. Mara?
Yep, pressure.
Right here?
Yep. Press the share.
And
The space bar or the next.
I want to start with some general principles. And I want to talk about 2 general principles here. The first is the broad government power to stop the spread of communicable disease. It's interesting, if you go onto Westlaw and look for Supreme Court cases, and you type in the words communicable diseases, you find very few cases. The same is true as I'll talk about with regard to quarantine. And there's no doubt that the most important Supreme Court case, and one that's likely to be much discussed now, is Jacobson versus Massachusetts from 1905. In fact, when the Fifth Circuit last week upheld a Texas law restricting abortion, something I'll talk about in more detail later in this presentation, it relied heavily on Jacobson versus Massachusetts. Jacobson involved a Massachusetts law that required that individuals be inoculated against smallpox. The Massachusetts law was a criminal statute. The punishment for violating it was $5. And the Supreme Court upheld the Massachusetts compulsory vaccination statute. I think the most important sentence from Jacobson that's likely to be much quoted is the one that I put on the top of the screen. Upon the principle of self-defense, of paramount necessity, a community has the right to protect itself against an epidemic of disease which threatens the safety of its members. The argument was made to the Supreme Court that it infringes liberty to force people to be vaccinated against their will. The individual said it should be for him to decide how to best protect himself from disease. It's notable that the Supreme Court explicitly rejected this and made clear that liberty is not absolute. I won't read the entire quote, but I do think it's key that the court said, but the liberty secured by the Constitution of the United States to every person in this jurisdiction does not import an absolute right in each person at all times and all circumstances free from restraint. The court says at the end of that paragraph that there can be restrictions for comfort, health, prosperity of the state. No, the court said that in order for a restriction on liberty to be justified, to stop the spread of a communicable disease, there has to be a real and substantial relationship to public health. And so the 2 quotes that I think will be most significant as cases are litigated now are on this screen, where the court says it cannot be in arbitrary or unreasonable manner or go beyond what is reasonably required for the safety of the public as to authorize no courts to interfere for the protection of such power. The quote that's on the bottom of your screen now was the one that the Fifth Circuit last Tuesday relied a great deal on in upholding the Texas law prohibiting abortions at this time. It says if a statute purporting an act to protect public health, public morals, or public safety has no real or substantial relation to those objects, or is beyond all question a plain, palpable invasion of rights secured by fundamental law, it is leaving the courts to adjudge and thereby give effect to the Constitution. And as I'll talk about, the Fifth Circuit says that this means that a restriction on rights, and in that case, abortion rights allowed, so long as there is a real and substantial relationship to public health. I might mention that post-Jacobson, lower federal courts and state courts have consistently upheld compulsory vaccination laws. Many of these state laws requiring vaccination against spread of communicable disease have exceptions with regard to those whose religion would not permit vaccination. But a few states have adopted laws without religious exceptions. Some states have said in order for a child to attend public school, the child must be vaccinated, regardless of the parent's religious beliefs or the parent's personal objection to vaccinations. All of these laws have been upheld. The lower courts have consistently read Jacobson versus Massachusetts as giving to the government broad power to order vaccination to stop the spread of communicable disease. The second general principle that I want to mention here concerns federalism and the relationship of state and federal power. It's generally thought that states have what is called the police power. It is their authority to do anything that is not prohibited by the Constitution. By contrast, the federal government has to point to express authority in the Constitution to be able to act. And so it's always been thought that states have the primary responsibility to take actions to protect public health, and the federal government's authority is much more limited. In fact, in California and in every state, there are statutes that allow the governor to declare an emergency, including for public health, and these statutes then give to the governor very broad powers. I'd here to start with Jacobson versus Massachusetts and the language that I put on the screen. And the reason I do is it talks about the states having the police power taking actions to stop the spread of communicable disease. It says the authority of the state to enact this statute inferred is commonly referred to as the police power, a power which the state did not surrender to become a member of the Union under the Constitution. Dan talked about this 2 weeks ago, and I don't want to repeat what he said, but there have been some developments in just the last couple of days that caused me to want to return to this as a basic principle. And so a couple of days ago, this was on April 10th, Maggie Haberman from the New York Times quotes President Trump, "The states can do things if they want. I can override it if I want," the president tells Peter Alexander. And to bring this up to today, you find a quote from President Trump's Twitter feed, and this is from this morning. And you see here that the president is saying the governors can make their choices, but the president has the authority to override those choices, saying that the president can order the country to be open even if the governors use their police power to close businesses. I want to be clear on this. President Trump is wrong as a matter of constitutional law. If a state orders closure of businesses pursuant to its police power, the president has no authority to countermand that and override it. The federal government can act only if there's a statute. In theory, Congress could adopt a statute that requires that businesses be open, and such a statute then would preempt state and local closure orders. But Congress has not passed such a statute. It's inconceivable to me that Congress would pass such a statute, and so under current law, no authority exists. 2 weeks ago, Dan presented to you the primary federal statute that exists in this area, the Public Health Act, 42 United States Code, Section 264. It says that it's the authority of the federal government to stop the spread of communicable diseases from one state to another or from coming into the United States. So this would give to the federal government the ability to stop people from coming into the country, or even conceivably from moving state to state to stop the spread of communicable disease. But the reason I put that language in italics is it's the power to take action to stop the spread of communicable disease. I don't see a way of interpreting that language to give the president, the federal government, the authority to order businesses be open if states believe that closure is necessary in order to stop the spread of a communicable disease. If there's a conflict between a federal statute or regulation and state or local law, it's a question of preemption. And generally, if there's a conflict between federal law and state law, federal law wins out. I don't think this federal law gives the authority of the federal government to countermand state closure orders. Indeed, there is a preemption provision here. It's sub E on your screen, and it's very clear. Nothing in this section where the regulations promulgated may construe as superseding any provision under state law, including regulations, including provisions established by political subdivisions of the state. So if there were any doubt about preemption, I think this makes it clear the federal government can't preempt state closure orders. So President Trump didn't order the closures a couple of weeks ago. President Trump simply said he'd like to see closures, but he didn't use any legal authority to impose it. And nor does he have the authority to order businesses to open if states want to close this. Now, President Trump could say he thinks businesses should open, and that might have an effect, especially in so-called red states, of their lifting closure orders. But I did want to cover this general principle that the primary responsibility with regard to protecting public health is at the state and local level. It's not something here, despite what President Trump says, that he could countermand. Well, with this in mind, I want to move now to the specific issues, and I want to talk about a number of specific issues that can arise with regard to civil liberties and the pandemic. The first of these to discuss is the constitutionality of quarantine and shelter-in-place orders. The Supreme Court has made it clear that states do have broad power to order quarantine for protecting public health. There's very few Supreme Court cases, I said, that use the word quarantine. I've gone through all of them on Westlaw, and primarily they're about the ability of states to take action to quarantine livestock to stop the spread of disease among animals. But there is a Supreme Court case that I think is language that's quite relevant. It says, in the absence of any action taken by Congress on the subject, it is well said that the state, in the exercise of its police power, may establish quarantines against human beings or animals or plants, the coming in of which may expose the inhabitants or the stock or the trees, plants, growing crops to disease, injury, or destructions thereby. And this is in spite of the fact that such quarantines necessarily affect interstate commerce. This is a power that's been recognized since early in American history. Not long after the Revolutionary War, there was an outbreak of yellow fever in Philadelphia. A quarantine was imposed to stop the spread of this communicable disease. It was upheld, and subsequently, though there's not many cases, quarantines have been upheld as well. And so on the next slide, I have a couple of more recent cases that have upheld the quarantines. Hickox versus Christie is the most recent case that I could find in the federal courts involving a quarantine. It involves a nurse who had been working in Africa at the time of Ebola and came back to the United States. And here was authorities that quarantined her for a period of about 80 hours to make sure that she wasn't contagious and couldn't spread the communicable disease, Ebola. And she brought a lawsuit challenging her quarantine and ultimately seeking money damages against the government that held her in quarantine. The federal district court in New Jersey ruled against her and upheld the power of the government to quarantine. And you see in the top paragraph there, the court expressing its support for the government's authority to quarantine to stop the spread of communicable disease. As I reread the case, I found the second quote interesting. Since as long ago as 1799, federal legislation has mandated federal non-interference and cooperation with the state's execution of their quarantine laws. This is relevant to what I was talking about a moment ago by saying that I don't think President Trump has the authority to override state quarantine orders. Another case, older case, but again, there's not many on quarantine, is the United States versus Shinnick case. It's a federal district court case from 1963, and it involved a woman who had been coming from Sweden and had been exposed to smallpox and whether or not she could be quarantined, and the court upheld the quarantine authority. But the ability of the government to quarantine is not unlimited. The courts say that it must be reasonably used. And I've been able to find cases earlier in American history and earlier in California history that found quarantines were not reasonable. I want to show you some of those cases. And I've lost, let's see if I can do the arrow there. The Injoho versus Williamson case is a fascinating one. It's from the Central District of California, and it involved the sealing off of an entire section of San Francisco to stop the spread of bubonic plague. And the district court invalidated this, saying it was unreasonable, unjust, and oppressive, and said that it was not in harmony with the declared purpose of stopping the spread of disease. What was notable in the decision is that it stressed that the area that was being subject to quarantine was an area where Chinese individuals lived. And the court clearly saw this as racially motivated. The court said, in the current language of constitutional law, that was done was under-inclusive, because there were areas in the city where there was the fear of the spread of bubonic plague that weren't covered, and there was over-inclusive in that there were many blocks where there was no bubonic plague that were closed off as well. And the long passage at the bottom of the screen is the court saying a key reason that it found this invalid was a denial of equal protection, the way in which this was really targeted at those of Chinese descent. Of course, it was a time of great bias and prejudice against Asians, and something that we've seen resurface, of course, in recent weeks. Another example of a case, let me again, rejecting quarantine was In re Smith, a New York case in 1895, where New York took the position that anybody who was not vaccinated would have to be quarantined. And the court invalidated that quarantine, saying that there had to be some reason to believe that people had been subjected to the spread of disease. Wanted to mention some California cases where quarantines were limited. Let me go back. These are fascinating cases that involve limits with regard to quarantine. Ex parte Dillon is a Los Angeles ordinance, and I want to read you the ordinance itself. It's not on the screen. It says, "It shall be unlawful for any person to rent any rooming house, lodging house, hotel, or other place of city for the purpose of having sexual intercourse with a person whom he or she is not married." What the case involves is women who were arrested at a brothel and subjected to quarantine. And the court said, there's no basis for quarantine here. What has to be done is reasonable. What's being done here isn't reasonable. Another example of a court in California striking down a quarantine is the In re Shepherd case, where again it involved a woman who was arrested for prostitution, and after being arrested for prostitution was subject to quarantine to stop the spread of venereal disease. And the court said, that's not permissible. There's a long line of cases in California that say in order to quarantine somebody, there has to be probable cause that the person might spread communicable disease. The first of the cases that I've listed here, application of Halco, involves a person who had tuberculosis and was subjected to a quarantine order. And the court said it was permissible because there was the spread of communicable disease. The probable cause standard is also articulated in the other two cases that I mentioned. In re King was a case that involved, again, stopping the spread of venereal disease. In Arata was an early case that says that you've got to have probable cause. It can't be mere suspicion. So what does all of this mean for now and the ability to have quarantine and shelter in place? My conclusion is that the government can quarantine individuals to stop the spread of coronavirus COVID-19, that a lesser form of quarantine is shelter in place. If the government could keep people from leaving their houses at all, the government can do something like shelter in place, which orders people in their homes except for limited purposes where they can leave. I imagine if people get criminally prosecuted for violating these shelter-in-place orders, they might bring a challenge. I don't think they'll succeed based on the liberty of the Due Process Clause or freedom of movement. Maybe they'll succeed on some vagueness challenges because there's aspects of the governor's order and the county orders that might be challenges vague. But in general, what I take from all of these cases is that in these circumstances, the government has the ability to quarantine. Let me move to a second application, and that concerns abortion. In the last several weeks, a number of states have adopted laws that prohibit non-essential medical procedures. They explicitly define abortion as a non-essential medical procedure, and they prohibit both medically induced abortions, abortions induced through drugs, and surgical abortions. Initially, several federal district courts declared these restrictions on abortion unconstitutional, and I put on the screen 3 of these cases that invalidated the state restrictions with regard to abortion. However, and I've alluded to this already, last Tuesday, the United States Court of Appeals for the Fifth Circuit upheld the Texas law in a 2-to-1 decision. The Fifth Circuit relied very much on the court's decision in Jacobson. Earlier, the Fifth Circuit had stayed the district court's temporary restraining order, but last Tuesday, the Fifth Circuit, in a very sharply worded opinion, reversed the district court. I mentioned at the beginning how much the Fifth Circuit relied on the Jacobson case, and I've included some language here. The court says it's just rational basis review. So long as the government is acting reasonably, it's permissible. The court says under the pressure of great dangers, constitutional rights may be reasonably restricted as the safety of the general public may demand. The federal rule allows the state to restrict, example, one's right to peacefully assemble, to publicly worship, to travel, and even to leave one's home. The right to abortion is no exception. And the court says in the second paragraph on the screen, the test, taking the language from Jacobson, is the government can restrict rights so long as there's a real and substantial relationship. The court says in the third paragraph, by all accounts then, the effect on abortion arising from the state's emergency response to a public health crisis must be analyzed under standards in Jacobson. Jacobson instructs that all constitutional rights may be reasonably restricted to combat a public health emergency. And the latter quotes on the page show you the Fifth Circuit's application of Jacobson. The court initially says this has a real and substantial relationship to public health. Texas claimed interest was reserving medical supplies, especially protection supplies, for essential medical procedures. Also, Texas said it wanted to limit contacts with doctor and patient to stop the spread of disease. And then the court says, and this is the next to last paragraph on your screen, the second Jacobson inquiry asks whether the Texas law is beyond question and palpable conflict with the Constitution. That's even more deferential to the government than a rational basis or a reasonableness test. This says that unless it is beyond question unconstitutional, it is permissible. And the Court of Appeal says this is allowed. And so at the very last paragraph on your screen, in sum, based on this record, we conclude that the Texas law, an emergency measure that postpones certainly non-essential abortions during an epidemic, does not beyond question violate the constitutional right to abortion. Now, I should note that very briefly at the end of its opinion, the Fifth Circuit said is leaving open the possibility of a so-called as-applied challenge. A particular woman could come to court and say that the Texas law for her was an impermissible undue burden, but the court didn't clarify what the woman would need to show in order to demonstrate the undue burden. I think that there's many things that are of great concern with regard to this opinion. It applies even to medically induced abortions where women are given 2 pills to take to induce the abortion, even to non-surgical procedures. Also, with regard to abortion, the Supreme Court has said that it is a constitutional right. It's hard to reconcile it being a constitutional right with the very deferential language that I read to you from the Fifth Circuit opinion. Also, for many medical procedures, there's no consequences to delay. For abortion, there's enormous consequences to delay. It can get past the time when the abortion is allowed, and also the longer into pregnancy, the more dangerous the abortion becomes for the woman. It is worth noting that the judges were ideologically divided. The judge who wrote the opinion, Judge Duncan, was appointed by President Trump. The other judge in the majority, Judge Elrod, was appointed by President George W. Bush. by all accounts, they're politically conservative. Judge Dennis, an appointee of President Clinton, wrote the dissent. On Saturday, day before yesterday, a petition for certiorari was filed in the Supreme Court. It is seeking to overturn the Fifth Circuit only as to medically induced abortions. The composition of the Supreme Court has changed since its last decision with regard to abortion in 2016. Many believe there's 5 justices, Roberts, Thomas, Alito, Gorsuch, and Kavanaugh, to allow much more government regulation of abortion. Maybe even at some point overrule Roe versus Wade. And this obviously is going to be ruled on by the Supreme Court very quickly. You might get an indication of where the justices are on abortion as a result of this. Let me move to a third particular right, and that concerns the First Amendment. And I want to talk a bit here about free exercise of religion and want to talk about freedom of speech and assembly. To what extent can the government keep people from gathering for religious worship? To what extent can the government keep people from assembling in large groups for the purpose of protest? I think under the general principles I mentioned, the government will be able to, if it chooses, keep people from gathering, whether it's for religious observance or for purposes of protest and assembly. But let me talk a little bit about each more specifically. With regard to the free exercise of religion, there is a quote from Prince versus Massachusetts that the right to practice religion freely does not include liberty to expose the community to communicable disease. Prince did not involve the spread of communicable disease. It was about application of a child labor law to keep a Jehovah's Witness parent from using her child to sell literature. And it ruled against the parent there and talked about the ability of the state to interfere with parental choices to protect children, but you find this quote. Day before yesterday, on April 11th, a federal district court in Kentucky handed down what I regard as a truly astounding decision. The federal district court said that the mayor of Louisville had prohibited religious gatherings on Easter Sunday and said that the mayor of Louisville had even prevented people from coming together at drive-in ceremonies in their cars. And the judge said in your first paragraph, on Holy Thursday, an American mayor criminalized the communal celebration of Easter. That sentence one this court never expected to see outside the page of a dystopian novel, perhaps the page of The Onion. But 2 days ago, citing the need for social distancing in the current pandemic, Louisville's Mayor Greg Fisher ordered Christians not to attend Sunday services, even if they remain in their cars to worship, and even though it's Easter. The mayor's decision is stunning, by all reason, unconstitutional. He says, the Louisville is violating the free exercise clause beyond all question. And the latter 2 quotes on the screen talk about the judge and his discussing how important it is for people to be able to gather for religious observance. Part of what made the opinion so stunning is it begins with many pages about the history of religion in the United States and religious persecution, especially religious persecution of Catholics. Now, there's many things about this decision that are worth noting. The mayor never issued any order making it a crime for people or prohibiting people from gathering for religious observance. The mayor said, quote, I would suggest you not attend, but there was never a prohibition. The mayor did not get people from getting together in their cars at a drive-in to worship. In fact, on Friday, the Kentucky Attorney General explicitly said that people could come together in their cars. And so if you read what the mayor of Louisville said, or what the Attorney General of Kentucky said, in no way is it a prohibition, and it certainly isn't a prohibition of people getting together in their cars. But this judge went out of his way to characterize it that way and to write a very strong opinion. Interestingly, the judge here is Justin Walker. He's quite young, he's 37 years old. He became a federal district court judge in October. On April 3rd, President Trump nominated him for the DC Circuit. When he'd been nominated for the district court, the ABA ranked him as unqualified for lack of experience. And it'll be interesting to see when his confirmation hearings come up for the DC Circuit, how this plays out. But as I said, it's just from day before yesterday, and it is very protective of free exercise of religion in the context of the pandemic. What about freedom of speech in assembly? As I alluded to, I think that the government can keep people from assembling, even though it might limit protests. As you know, there's orders that limit the ability of people to come together in groups of more than 10, or in some places more than 50. Obviously, that would stop mass demonstrations, and I think that would be found permissible to stop the spread of communicable disease. The government can't, though, use this as a basis for restricting the content of speech. In my introduction, I mentioned what countries like Jordan, like Hungary, like Thailand are doing, where they're very much punishing speech based on its content. That's not allowed, and I think that would be declared unconstitutional. The government can't control the content of the message, even in the time of pandemic. But I did want to mention one case that's been filed with regard to freedom of speech. It's the case that's on your screen now. It's the Washington League for Increased Transparency and Ethics versus Fox News that was filed in Washington State Court on April 2nd. The claim here is that Fox News has spread false information about the threat from coronavirus, that this false information is dangerous to public health. And some of the things that in the complaint is a quote from Trish Regan, who has since left Fox News, who called the coronavirus, quote, yet another attempt to impeach, demonize, and destroy the president. When she spoke on Fox News, there's a graphic next to her that said, coronavirus impeachment scan. Janine Perot said, all the talk about coronavirus being so much more deadly than the flu doesn't reflect reality. Sean Hannity said that the coronavirus, like the flu, healthy people generally, 99% recover fast if they contract it. Devin Nunes went on Fox News and told Americans to stop panicking and just go out. The complaint points out that the Pew Research Institute did a survey that found that 79% of Fox News consumers believe the media slightly or greatly exaggerated the risks of the pandemic. And so this is a lawsuit against Fox News. I think Fox News will and should prevail in this lawsuit. Opinion is protected by the First Amendment, and what was said could often be regarded as opinion. But even if it's fact, false facts are generally protected by the First Amendment. The Supreme Court has made it clear that the government generally can't prohibit false speech. There's exceptions. Lying under oath can be punished as perjury. False and deceptive ads can be punished. But the Supreme Court has made clear that false speech has to be protected in order there to be the breathing space for First Amendment freedoms to survive. So I find what Fox News has done here by spreading false information is a terrible disservice to the American people, but I don't think this lawsuit is likely to succeed. I think there will be other issues that come up with regard to freedom of speech, and this will touch on some of the things that Andrea Roth may discuss next week. As courts go to online proceedings, there is a right of the public to be present. This is true in criminal proceedings, but also this California Supreme Court has said in civil proceedings. And how will the right of the public to be present be reconciled with proceedings that are online? But I don't have any cases yet about that. The fourth area that I want to talk about concerns voting in elections. The Supreme Court long has held that the right to vote is a fundamental right. Courts have the obligation then to protect this and to make sure that any restrictions on this meet what's called strict scrutiny, be necessary to achieve a compelling purpose. I expect that there'll be a good deal of litigation as we come to November, especially if we're dealing with the coronavirus epidemic, concerning protecting the right to vote. There was already one case about this, and it was a Supreme Court decision from just last Tuesday, or just last Monday, April 6th, it was a week ago today. The case is Republican National Committee versus Democratic National Committee. The Wisconsin primary went forward last Tuesday. Huge numbers of people requested absentee ballots, but it turned out that the absentee ballot requests had not been processed, and the absentee ballots had not been sent to many people in time for them to be able to vote. The deadline for postmarking absentee ballots was supposed to be Election Day, April 7th, but a federal district court judge extended that to April 13th, giving 6 extra days for them to be postmarked, and still be able to be counted. The United States Court of Appeals for the Seventh Circuit upheld the district court order in this regard, but the Supreme Court, in a 5-4 decision, reversed and said that the district court acted improperly, and as a result, in order for an absentee ballot to be counted, it had to be postmarked by the designated date, April 7th. The court's majority opinion was per curiam, which means it's an opinion of the court. We don't know who the author is, but we know the 5 justices who signed on to it were Chief Justice Roberts, Justice Thomas Alito, Gorsuch, and Kavanaugh. Justice Ginsburg wrote a dissent that Justices Breyerson and Kagan signed on to. The Supreme Court said there's a long-standing principle that federal courts not change election rules right before the election. The second paragraph that you find on your screen, this court has repeatedly emphasized that lower federal courts should really not alter election rules on the eve of an election. The Supreme Court said the federal district court violated that by changing the deadline for postmarking of absentee ballots. And therefore, you find in the last paragraph, the court says, subject to further alteration, the state may choose to make state law. In order to be counted in this election, a voter's absentee ballot must either be postmarked by election day and received or hand-delivered or provided in state law by April 7th. In other words, all the people who didn't get their absentee ballots by election day wouldn't be able to vote absentee. And I'm sure you saw the pictures in the news last Tuesday of long lines of voters standing outside polling places in Wisconsin. Justice Ginsburg wrote a very strong dissent. She said, because gathering at the polling places now poses dire health risks, an unprecedented number of Wisconsin voters, the encouragement of public officials, have returned to absentee voting. But about 1 million voters requested absentee ballots in this election than in 2016. Accompanying the surge of absentee ballots requests has heavily burdened election officials, resulting in a severe backlog of requests, but not promptly mailed to voters. In the second paragraph, she elaborates on this, and she concludes, the majority of this court declares that this case presents a narrow technical question. That is wrong. The question here is whether tens of thousands of Wisconsin citizens can vote safely in the midst of a pandemic. Under the district court's order, they would be able to do so. But even if they received their absentee ballot in the days immediately following election day, they could return it. With the majority staying in place, that will not be possible. Either they'll have to brave the polls, endanger their own other safety, or they'll lose their right to vote through no fault of their own. That is a matter of utmost importance to the constitutional rights of Wisconsin citizens, the integrity of the state's election process, and the most extraordinary time, the health of the nation. One of the things that's important to note about this case is it was the Republican National Committee that did not want the extension of the deadline with regard to absentee ballots. And it's the 5 justices appointed by Republican presidents who came down on that side. It was the Democratic National Committee that wanted to extend the deadline, and the 4 justices appointed by Democratic presidents who wanted to extend the deadline. One can't help but think back to Bush versus Gore in the year 2000. As I said, I expect there'll be a good deal of litigation in November, where polling places are closed or absentee ballots are not available, and courts are going to become very involved. And it'll be interesting to see how this precedent matters as courts try to make sure that the right to vote is protected while also safeguarding public health. The 5th area I want to talk about doesn't have cases that have yet been brought that I know of, but I expect we will see them. And this concerns the takings clause. The 5th Amendment to the Constitution says that the government can take private property for public use, but it must pay just compensation. And under the takings clause, so there are 2 kinds of takings. One is a possessory taking. A possessory taking is if the government confiscates or physically occupies property. The law is overall clear. If the government confiscates or physically occupies property, the government has to pay compensation. So if the president uses the authority under the Defense Production Act that Dan talked about 2 weeks ago, seizing a business is a taking that requires just compensation. One interesting question about possessory takings that's not been resolved by the Supreme Court is whether there's an emergency exception. Might there be situations because of emergency that even though it's a possessory taking, the government won't have to pay just compensation. And there's at least one case that suggests an emergency exception for possessory takings. And it's what I put on the screen, United States versus Caltex. And as the screen points out, the Supreme Court found there was not a taking when the government destroyed a company's oil facilities in the Philippines to keep them being taken over by the Japanese during the early days of World War II. The court acknowledged the government had taken private property, but says, and I quote the language you see in the second paragraph of the screen, in times of imminent peril, so when fire threatens a whole community, the sovereign could with immunity destroy the property of few, the property of many and the lives of the more could be saved. That would suggest a emergency exception for possessory takings. But there's also a case from around the same time that rejected this. It's the United States versus Pee Wee Coal Company case. The government found that a seizure of a coal mine, even in the context of wartime, still required that there be compensation because of an actual taking and control. So if the government comes to confiscate or physically occupy property, I think the owners have a strong claim that they get just compensation, but do keep in mind Caltex. The other kind of taking that exists is a regulatory taking. This is a government regulation that may limit the value of someone's business. So for instance, zoning ordinances are a form of regulation that might be challenged as a taking, or think of other kind of health and safety regulations. Here the court is much more deferential to the government. Here the court has said that government regulation is permissible in our taking, so long as it leaves some reasonable, economically viable use of the property. The leading Supreme Court case is Penn Central versus New York City, where it articulates a three-part test that I put on your screen. Here's why I talk about this. What about businesses that are being closed by government order? And in many cities, all non-essential businesses have been closed. The businesses lose tremendous amounts of money. Maybe the businesses will even have to close permanently. Might they bring a challenge saying that this is a regulatory taking? It's not a possessory taking. It's not the government confiscating the property, but could it be brought as a regulatory taking? My sense is that the government is very likely to win those cases and the business owners are likely to lose. I think this is going to be seen as a necessary regulation for public health. And when the court uses the balancing test of Penn Central, I think the government's going to prevail and the business owners are going to lose, at least under current circumstances where it's about stopping the spread of pandemic. The sixth and final right that I wanted to talk about concerned the right to travel. When Dan did his talk a couple of weeks ago, there were a number of questions in the chat about the right to travel. And so while I don't know of any litigation going on right now about it, I thought I'd at least review for you the basic Supreme Court cases. The Supreme Court has said that there is a fundamental right to interstate travel and migration. Therefore, generally, laws that keep people from moving from state to state have to meet strict scrutiny. And that's to achieve a compelling purpose. In fact, in helping to answer one of the questions 2 weeks ago, I mentioned Edwards versus California. Edwards involved a California law that said it was a crime to bring an indigent person into the state during the Depression. In other words, in order for a person to move to California, the individual had to show the means for supporting himself or herself. The court, without a majority opinion, declared the California law unconstitutional. Justice Douglas's language has been much quoted. The right of persons to move freely from state to state is so fundamental. The right to move freely to state is an incidental of national citizenship, protected by the Privilege and Immunities Clause of the 14th Amendment against state interference. United States versus Guest involves a federal statute that makes it a crime to interfere with interstate travel, and it's a civil rights statute. And you find very strong language in Guest, a civil rights case, about the right to travel as fundamental. The court says, although the Articles of Confederation provided the people of each state shall have free ingress and regress to and from other state, the right finds no mention in the Constitution. The reason is suggested as right so elementary was conceived from the beginning to be a necessary and common to the stronger union the Constitution created. In any event, freedom of travel in the United States is long regarded as a basic right under the Constitution. The most recent case on this was Sines versus Roe in 1999. Involved a California law that said if a person moved into the state from another state, welfare benefits the first year in California, the level the state moved from. So if a woman who moved from Mississippi to California, under the law, her benefits in California for the first year here would be at the Mississippi level. The Supreme Court 7-2 declared this unconstitutional, and in very strong language that I put on the screen speaks of the fundamental right to move from state to state. Now, it's possible that a state could try to restrict people coming from other states. Undoubtedly, preventing the spread of a communicable disease would be a compelling interest. But I don't know that this would be found to be a necessary means for stopping the spread of communicable disease, or as narrowly tailored as possible. Now, what I've spoken of here is the right to travel from state to state. I should point out there is no fundamental right to international travel. The government can regulate people with regard to international travel so long as it's reasonable, so long as it meets a rational basis test. And so the government very much can limit people leaving the country or prohibit people from entering the country. There's no fundamental right to international travel. So that's what I wanted to share with regard to civil liberties in the time of a pandemic, and especially to talk about the most recent cases. And I've saved the remaining time for questions. Let me try to go to stop sharing screen. And with that, I'm glad to take questions by the chat function or by the raised hand function. And I'm also glad to have others with expertise, the other constitutional law professors, chime in as we go along. There's a question on the screen. And Whitney, can everyone hear okay?
Yes. Would you like me to read the question?
Oh, I can read it.
Okay.
Thank you, though. What happens when a woman in Texas attempts to have an abortion in Texas? We're still in ordinary times with legal and tight of an abortion, but the restrictions on abortion in the pandemic is denied an abortion. She then tries to have an abortion after the restrictions are lifted. But this point is so far along in pregnancies past the normal window when the government can restrict abortion. Will this woman have a right to abortion? Will she completely lose her right to have an abortion, even though she first attempted to exercise her rights when it had been constitutional to do so? It's a great question. We don't know the answer to that question. The Supreme Court in Roe versus Wade said that the government can prohibit abortion after viability, the time at which the fetus can survive outside the womb. In Planned Parenthood versus Casey in 1992, the Supreme Court reaffirmed that the state prior to viability cannot prohibit abortion, but the state after viability can prohibit abortion, except when necessary to protect the woman's life or health. But what of a situation where it's the government itself that keeps the woman from having an abortion? Would there then be a right to post-viability abortion? I think there's an argument. On the other hand, Roe and Casey at least implicitly say that the government has a compelling interest in protecting fetal life after the moment of conception, after the moment of viability. Roe explicitly says there's a compelling interest after viability, and Casey adopts the viability standard. And I think that compelling interest would likely be enough to deny the woman abortion. I briefly said, because the Fifth Circuit in its opinion last Tuesday only briefly said, that there might be an as-applied challenge available. And I think where this could come up is a woman was reaching the point of viability, could go to court and ask for an exception to allow her to have an abortion. Now, one thing that I didn't mention and that the Fifth Circuit doesn't discuss is that medically induced abortions are possible only during the earlier time of pregnancy. RU46, for example, can't be used for second trimester abortions, sometimes not even for late first trimester abortions. So the availability of medically induced abortions is quite important and is the focus of the Supreme Court petition. But the bottom line is we don't know the answer to your question. I think the most important thing would be a woman who's seeking an abortion as it gets closer to the time of viability to go to court and ask for an exception from the Texas law is applied to her. And at least the Fifth Circuit left open that possibility.
There's a couple more questions.
Okay.
In terms of In re Abbott, how would preventing someone from having access to an abortion reduce contact between patients and doctors and use of medical supplies? If someone doesn't have an abortion and stays pregnant, Won't they need to have frequent doctor's appointments anyways? This rationale on the part of the state of Texas doesn't seem convincing.
I think that's a great argument. I imagine what Texas would say in response is that there's a need at this moment to conserve medical supplies because of shortages of things like masks and facial protective equipment, that the hope is that several months from now that'll alleviate it. So the need to save those supplies right now justifies this. Also, I want to emphasize that there's no reason this should apply to medically induced abortions, because a medically induced abortion is a woman be given 2 pills, take some time apart, and that doesn't involve any medical supplies. Also, except for restrictions on telemedicine, the woman could be prescribed those over the phone without having to meet a health professional.
In regards to testing, is it the right for any government institution to identify who is positive and make it public for the good of the community?
It's an interesting question in terms of privacy. What if the government were to publicize who tests positive? Does the right to privacy there get infringed by the government? The Supreme Court has spoken of privacy, but there are only a couple of Supreme Court cases that have ever dealt with informational privacy under the liberty of the due process clause. One was Doe versus Whalen, and the other was NASA versus Nelson. Both of these cases suggested that there might be a right to keep information secret as part of privacy under the Constitution, but both rejected the privacy claim there. There is a tort that can be brought against individuals for the public disclosure of private fact, but I think the interesting question is, if the government chose to do this, would there be a privacy claim against the government under the due process clause? And here the law is just not developed enough in order to answer. Also, there'd be the question of, even if there were infringement of privacy, would it be justified to stop the spread of communicable disease?
Okay. Are there any Fourth Amendment implications for mass surveillance to track coronavirus contacts?
I think so, depending on how it's done. The United States Supreme Court in June 2018 in Carpenter versus United States held that for the government to access a large amount of stored cellular location information is a search within the meaning of the Fourth Amendment. In Riley versus California, the Supreme Court said that people have a privacy interest in the contents of their electronic equipment. So I think if the government is using cell phone technology to track people's movements, there's certainly a privacy claim under the Fourth Amendment. Now, again, the law isn't very developed here. Carpenter's a June 2018 case, and it's about the government accessing a large amount, I think it was 127 days of stored cellular location information about a person. So at what point does it become a Fourth Amendment issue in terms of tracking? I mentioned that the Israeli government has engaged in the practice of tracking cellular information so as to be able to keep track of people's movements. It's a great question, and we just don't have law on it at this point.
As far as state and local quarantining, shelter-in-place, and business closure orders, it sounds as though if they are challenged, courts will just be asking whether the orders are reasonable, which looks like a rational basis review. Is there any reason to think that a heightened standard of review would or should be applied to any of these orders?
I think that the questioner is right. I think it will be rational basis review. I think the court will ask, is it reasonable under the circumstances? My own sense is, given how communicable coronavirus is, the health consequences, and how it's lethal in a certain percentage of instances, the courts will side with the government here. But I do want to emphasize, too, that the government's action has to be reasonable. And that's why I went through a few cases where quarantine orders were found to be unreasonable under the circumstances. So based on what's happening now at this moment in time, I have no doubt that the courts will side with the government for shelter in place and quarantine. There may be a point in the future, if those orders continue, where courts will be less likely to defer to the government.
There is a recent case against Governor Cuomo in New York relating to the free exercise of religion and freedom of assembly under quarantine. Thoughts on this?
Yes, I think, as I said in my talk, that restrictions on people gathering, whether for religious purposes or assembly purposes, will be upheld. When you're dealing with a disease that is as communicable as coronavirus, I think restrictions on people gathering in groups larger than, say, 10, or groups where people are closer than 6 feet, will be upheld at this point in time. I think, again, it's going to be a reasonableness type test with great deference to the government that this is about stopping the spread of communicable disease. I see one question on the screen that says privately. Let me address this. What about state orders requiring gun stores to close? What are the Second Amendment implications? I actually had that as another slide, but was worried about time, so didn't include it in the PowerPoint. Los Angeles has said that it's closing non-essential businesses, and it lists gun stores as non-essential businesses, and a challenge has been brought to that by gun store owners. What's important to recognize here is there's really only one Supreme Court case that protects Second Amendment rights in terms of the content of the Second Amendment, and it was limited as holding. From 1791 to 2008, the Supreme Court never struck down any federal, state, or local gun regulation. In the few Supreme Court cases that dealt with the Second Amendment, the court said that the Second Amendment means what it says. It's a right to have guns for purpose of militia service. But then in District of Columbia versus Heller in 2008, the Supreme Court struck down a DC ordinance that prohibited possession or ownership of firearms. It was a 5-4 decision. Justice Scalia wrote for the court, but the court was limited. It said there's a right of people to have guns in their home for the sake of security. And the court was clear it wasn't an absolute right. What the court didn't deal with there was, is there a right to have guns outside the home? And what the court didn't deal with there is, to what extent are restrictions on gun sales a violation of the Second Amendment? So it takes some extension of Heller to say that the Second Amendment protects a right of gun stores to be open, especially when other non-essential businesses are being closed. But of course, what gun store owners are saying is, just as with regard to, say, abortion rights, the Second Amendment is a right, and this is a restriction on people's ability to get guns. Be interesting to see lawsuits have been filed and what happens to them. But I do want to stress that the only Supreme Court precedent is a very narrow precedent about the right to people have guns in their homes for the sake of security. Go ahead.
I've received a question. Is there a point in which false speech is not protected by the First Amendment if it endangers the public, e.g. Trump promoting use of unproven anti-malaria drugs? If the public relies on this information to their detriment, could there be claims against President Trump?
Well, first, the president has absolute immunity to civil suits for money damages for anything taken and done while in office and carrying out the presidency. So the President Trump could not be sued for money damages. And that's the Supreme Court case Nixon versus Fitzgerald from 1982. Second, in terms of false speech, there are times when false speech can be punished, and I gave those examples, perjury, lying in court under oath, or false and deceptive advertising. And yet, opinion, expressing views, isn't subject to liability, and President Trump could be said to have expressing an opinion, even if he could be sued. And also, the United States Supreme Court has said there's great protection for false speech. The key case was United States versus Alvarez in 2012. Involved a federal statute that made it a federal crime for a person to falsely claim to receive military honors or decorations. And the Supreme Court declared this law unconstitutional, very expansively talking about the protection of false speech under the Constitution. In New York Times versus Sullivan in 1964, the court talked about there needs to be protection of false speech, so there's the breathing space for freedom of speech to thrive. So I think it'll be very hard to sue anyone and impossible to sue the president for the false speech they do. Now, if a company in its commercial ads makes false claims, then I think it's very different.
Do we have time for one more question?
Yes, I think so.
Okay. What do you think about the government under the recently passed CARES Act using taxpayer funds to cover church payroll? How does this square with the separation of church and state?
I have opined on this, as have several constitutional law professors who have been consulted by some congressional staff. I think it violates the First Amendment for the government to use government funds to pay the salary of clergy members. And even the most recent Supreme Court cases that have allowed government funds to be used for religious institutions, such as Trinity Lutheran versus Comer in 2017, have drawn a distinction between using money to pay for training of ministers or here minister salaries, as opposed to for more secular purposes. Interestingly, the CARES Act limits the ability to use this money for purely sectarian purposes, like paying clergy salaries. But the Small Business Administration has issued an opinion letter that they believe that Trinity Lutheran versus Comer, the case I mentioned, says the government can't exclude the money from going to pay clergy salaries. And I believe that even under the most deferential standard of the Establishment Clause, for the government directly be paying clergy salaries is likely to be found to be a violation of the Establishment Clause. But I do want to clarify the difference between what the CARES Act prevents and what the Small Business Administration is saying in terms of the use of the money. I think we're probably out of or near out of time. If I didn't get to your question, just email me your question and I'll answer it as soon as I can. But I hope this was helpful with regard to discussing some of the issues, and especially current ones, with regard to civil liberties and the coronavirus. Next week, Andrea Roth is going to be talking about the coronavirus relative to the criminal justice system. In 2 weeks, Catherine Fisk is going to be talking about the coronavirus regard to, and Katie Albiston also, concerning coronavirus and employment and labor issues. We're going to then not hold these programs for a couple of weeks during the final exam time, but then we'll resume after that with Katerina Linos doing a talk on coronavirus with regard to international law issues. Thanks so much for tuning in today. I hope everyone take care, be well, be safe.